Hello, and welcome to Virtual Legality. I'm your host, Richard Hogue, managing member of the Hogue Law business law firm of Northville, Michigan. And that means, as a business law firm, that I draft end-user license agreements, software licenses, and website terms of service regularly as a day job. And I have a lot of thoughts about this story that you can see on your screen from GameFile of Stephen Totilo and what it means for Nintendo owners, or what they think are owners, of the new Switch 2 system in particular. Now, this article reads, as a headline, Nintendo warns it may brick Switch systems, meaning it can make them inoperable, whose users bypass, modify, decrypt, defeat, tamper with their games and services. And this was the first time I saw this story discussed. It says it was May 8th, 2025. It also says this is a paid article. And I want to disclaim that Stephen Totilo is one of my favorite writers working in the video game space right now. And so I do pay for his Substack, but I want to disclaim that because this is paid content. He says he received an email at 11:39 p.m. that had the subject line, updates to Nintendo account user agreement and Nintendo privacy policy. And if you're in any kind of video gaming or any kind of other software customer, you know that you get these emails from time to time, because the licenses that you agree to when you use software all have within them a provision that says we as the software provider can change these terms of service at any time. But when they do change them, they give you a notice like the one listed in this email. And he says, in response to that email, it's a good thing I looked. Most of the changes, just over 100 edits by my count, were made to the Nintendo account user agreement, a digital document that people click on in order to use online connected Nintendo services. That's another aspect of this story that we're going to discuss a little bit further on in this video. But an important thing to note here is that most of these companies, Nintendo, Microsoft, Sony, anybody else that you might be playing video games through, have a number of different interlocked, nested together agreements, some of which are for the platform, some of which are for the hardware operating system, some of which are for the content or account services, as we see described here. Now, Nintendo actually tries to flatten that ecosystem of documents down to mostly one that you have to interact with as a customer, and that has a lot of benefits. You don't have to read a number of different documents, but it also has a lot of downsides because there's a lot of conflated ideas in the Nintendo document that may or may not apply in the very nefarious ways that some are reading into it. So with that said, I want to highlight what Stephen Totilo identifies as one of the biggest items here. The most strongly worded change from Nintendo amid their swath of updates is a major expansion of the company's long-standing warning to the gamers it seems most frustrated with these days. Those who hack or modify its console and games, run emulators, and in Nintendo's assessment, foment piracy. Nintendo's old user agreement, effective since April 2021, said, you are not allowed to lease, rent, sublicense, publish, copy, modify, adapt, translate, reverse engineer, decompile, or disassemble all or any portion of the Nintendo account services without Nintendo's written consent, or unless otherwise expressly permitted by applicable law. Here's the new, way more intense version, complete with the potential punishment of your Switch being bricked by Nintendo. Without limitation, you agree that you may not publish, copy, modify, reverse, engineer, lease, rent, decompile, disassemble, distribute, offer for sale, or create derivative works of any portion of the Nintendo account services. Now, one thing I do note as a lawyer here is that there are a number of ways to write provisions like this. And the first thing that I see here is that the new lawyer working on this version of the license agreement is clearly the kind of lawyer that likes to list out every possible thing that they can think of. If you've never worked with a lawyer before, you should know that lawyers, especially business lawyers, are primarily in the business of trying to figure out ways in which the company that they are representing could be harmed in the future by not including something in the contract in front of them. So a type of lawyer looks at this and says, it's better to pack something and not need it than need it and not pack it, imagining a future lawsuit or court that would say, hey, you know how to write these words on the page, and you only said decompile and disassemble. You didn't say anything about distributing or offering for sale or creating derivative works, etc. And so various lawyers in corporations, working for corporations in outside firm capacities like I do at Hogue Law or elsewise, will have different kind of risk aversion levels and know their clients and what they want in their documents a little bit better. But it does mean that language can change that really doesn't change the substance of the provision. So here we've got a few new entries. I've highlighted them in yellow, but it doesn't actually change much of what we're talking about here. Nintendo always reserved all the rights afforded to them under copyright law, which includes the right to prevent derivative works, includes the right to prevent distribution they don't like, etc., etc. They're just listing them out more specifically here because The lawyer, whoever's in the room here drafting this version of the document, likes to list things out more specifically. Next, we see a reference to bypassing, modifying, decrypting, defeating, tampering with, or otherwise circumventing. Keep a note on that word circumvent. Any of the functions or protections of the Nintendo account services, including through the use of any hardware or software that would cause the Nintendo account services to operate other than in accordance with its documentation and intended use. So this is aimed at what Stephen Totilo identified earlier, which is things that are going to break the way a Nintendo device functions through a reference to the account services specifically. The next item is you can't obtain, install, or use any unauthorized copies of Nintendo account services, the services specifically, but that does include video games in the concept, or exploit the Nintendo account services in any manner other than to use them in accordance with the applicable documentation and intended use in each case. Now, that's a lot of words, right? That's a lot of lawyer drafting there. But ultimately, in my view, that is almost entirely covered by what was already in the Nintendo Old User Agreement in April of 2021. Now, that said, they did add a bit of language here that I think has gotten everybody a little concerned about what they're purchasing with the Nintendo Switch. And that is that Nintendo added language that said, you acknowledge that if you fail to comply with the foregoing restrictions, Nintendo may render the Nintendo account services and or the applicable Nintendo device permanently unusable in whole or in part. Now, this is one of those areas where I think Nintendo trying to conflate things like the operating system license with the video game license and the account services concept is a thing that makes it a little bit harder to read, not just for the layman, not just for anybody that's not been to law school that just bought a Nintendo Switch, but also for the lawyers. Because the best reading of this to me, what Nintendo seems to be aimed at here, is that we can turn off your ability to use the Nintendo account services, what you purchased through the eShop, and those kinds of things, and not necessarily brick your console, but it's not clear here. And bricking here would mean the disabling of the operating system. Understanding that when you purchase a Switch 2 or any other piece of technology in 2025, what you are most likely purchasing is a bit of hardware in the real world, the chips, the actual box that you are putting under your TV, the dock that you're putting it in the case of a Switch, and the software that actually runs that hardware, right? If Nintendo bricks it, it doesn't mean that they run into your house and steal your Switch. It just means that they steal the functionality of the Switch. And that's the same effect for you and me. But it does mean that they are talking about software when they're talking about bricking something, not lighting your system on fire. So when we talk about these things, it's important to note here that we're talking about a combined system of hardware and software acting together. And what Nintendo is basically claiming dominion over is its software. That because you have to connect online to use the Nintendo account services anyway, and probably to operate your Switch in most cases that you're going to operate it on in 2025, Nintendo reserves the right to say, if you do very bad things that we don't like, we can say your operating system doesn't work, which means your Switch doesn't work. That's not great. I'm not going to sit here and tell you that you should be happy about these technology companies having the ability to do that. But I want to get into this more fulsomely so that we can better understand what the current ecosystem of video game devices is in any event and what this language actually means. The other thing I would add from a purely lawyer-to-lawyer term of art here is that I don't think you acknowledge is actually the right way to describe this, because you can acknowledge all sorts of things that aren't true. So Nintendo saying you acknowledge that if you fail to comply, we can brick your system, maybe, is probably not as useful as a bit of language that I like to put in my agreements, which is user acknowledges and agrees, or you acknowledge and agree that we can do these things. That gives the party the right to actually do those things. You acknowledge that we can do this doesn't actually put that legal right in play. That's angels on the head of a pin. That's very legal easy, so don't worry about that too much. But I did want to state that this language is not language that I love here, and that's because it can't itself create a new right outside of the law just with this provision, even though contracts in general are putting forth rights and obligations that either side has, and you could write this in a way that maybe is a little bit more protective of Nintendo if they decided to do that in the future. But with that said, I did want to point out that Stephen Totilo, who I again think is an excellent journalist in this space, doesn't just say, wow, that's a horrible thing that Nintendo can do. He says not that surprising, of course. We're just seeing Nintendo's recent legal energy funneled into its user agreement. So he's taking this with the kind of sober approach that I expect from him at this point in time, saying, okay, there's a lot of legalese here and it doesn't look great and we should note it. I'm writing an article about it after all, but it maybe isn't the end of the world. But not everybody takes that exact tack, and we'll see that when we get to the response section of this video. The other thing I wanted to point out is looking at this document, there's a lot going on here that maybe is not something that people are talking about as much as they maybe should be. One thing Stephen Totilo does note in his article is that they have added this concept in at the beginning of their document that says, your parent or legal guardian agrees to the Nintendo account user agreement if you're a child and you otherwise click through to use your Nintendo Switch to play Mario Kart World. And one thing I note here as a top line item is that this does appear to be Nintendo being very aggressive in their documentation, because in most cases, this language isn't going to work, right? And there's nothing preventing anybody in any space, in any user license agreement, in any other context, from putting things in the contract that a court is not going to uphold. It's maybe not a great idea, but you're trying to signal to people of what you're trying to achieve. And this case is one where Nintendo got burned by the fact that kids had agreed to certain terms. With respect to the Joy-Cons, I believe, on the Switch 1 system. And some courts said, well, that's not the adults that agreed to those terms, those limitations on the ability to sue, for instance. And so Nintendo's trying to cover that by saying, hey, kids, don't sign this if you're under age 18, but if you do, your parents or legal guardians are on the hook. That probably doesn't work in contract law, because you can't just grab someone else that's not a party and say you're now a party to this document. Things get a little bit confusing with respect to guardians and kids, because you do have certain responsibilities as a parent or guardian for the actions of your children in the United States and in other jurisdictions' laws. So this is probably a gray area, but it does at least speak to the fact that Nintendo is trying to be aggressive, doesn't necessarily care whether or not this is fully enforceable, as much as it cares about signaling that it wants it to be read this way, and that if you are a parent or legal guardian, you should be concerned and you should be wary of what your child is doing, so that we don't have to have this fight in court again in the future. Now, importantly, this document, as Mr. Totilo said, says it governs your use of the Nintendo account services through your Nintendo account. And in definitions, it establishes that the Nintendo account services, including, for example, video games, as well as any other Nintendo products that require the use of a Nintendo account, are all included in this definition. So they're grabbing things you buy from the eShop. They're grabbing your Switch and your Switch 2 when they're discussing what they can do under this license. You acknowledge again that if you fail to comply with the foregoing restrictions, Nintendo may render the Nintendo account services and or the applicable Nintendo device permanently unusable in whole or in part. Now, I think in all likelihood, that's best read to mean that we'll shut down your access to the Nintendo online services, the eShop and what have you, rather than bricking the whole system, because that would have all sorts of public relations ramifications that Nintendo probably doesn't want at this point in time. But I can't guarantee that. Nobody can really guarantee that for you until Nintendo decides to do anything with this language. But again, based on all the other inclusions, including what we just talked about at the top and the additional language in this section, this appears to be a document written by a lawyer that's trying to describe every possible thing that could happen in the future and wants Nintendo to have the armament that it thinks that they would need in the case that something like this happened, even if they didn't intend to use it, right? One thing that other people should note about these documents is that there's a lot of landmines in these things. There's a lot of things that companies otherwise reserve the right to do that in all likelihood they wouldn't want to do, because it would have all those negative public relations ramifications. It wouldn't be a great market idea to do very bad thing X, Y, or Z, but they have them in these documents because some lawyer somewhere said, you're going to regret it if you don't have this bit of language somewhere in the future. And the people in the room said, okay, we'll go with that. That's always a push and pull with businesses and lawyers. Lawyers always are looking for every possible bad thing that could happen and saying you should put this language in or else you're going to get burned in the future. Lawyers develop that kind of muscle memory because they're worried about being sued for malpractice, for the company flipping around on them in the future and saying, you never told us this could have happened and your failure to do so is malpractice, and all these various things that are bad things about the way that this whole process works. But that's how this language gets in there. And I don't believe there's any strong intent by Nintendo to actually start bricking systems out there in the market, because I can imagine that would have a very negative ramification on the way they actually operate their service. That said, there's a bit more in here that is mostly the same as it was in the earlier version of this document, but is important for understanding what's happening here. Breach and termination of the agreement, Section 13. Nintendo may terminate this agreement or suspend your access to any or all Nintendo account services in our sole discretion and without prior notice to you if you violate this agreement. Now, important to note here is that this doesn't require a separate lawsuit, right? The only people that are deciding whether you violated this agreement for this provision to take place, for Nintendo to have these rights, is Nintendo itself. And this is a way that people should be concerned about end user license agreements in general, which is to say, we've got all sorts of court protections and things that I can talk about in Virtual Legality or elsewise that talk about companies that have to go through a process before they can do very bad thing to you. Contracts are different. Contracts, you're agreeing to the bounds of what each party can do in any given circumstances. Here, it says Nintendo can do these things if you violate this agreement, but doesn't say if a court finds that you violated this agreement. It just says if you violate this agreement. And by its terms, that means if we at Nintendo decide that you violated the agreement, or as they say further on, if we have a reasonable belief that such a violation has or will occur. We just think you're a bad guy and we think you're going to steal our stuff. Or as we otherwise determine to be reasonably necessary for legal, technical, or commercial reasons, right? Not legal reasons. If we think that it's a bad idea commercially for you to have access to your Switch account, then we can cut it off. And that's worth noting. One of the reasons I made Virtual Legality in the first place was for people to take better note of what's in the contracts that they're signing so that they can understand what the playing field is in the future on any and all things related to video gaming or otherwise things that they are interested in. Now, to some extent, people read what they want to read and they see the parade of horribles and say all these corporations are evil, etc. But what I want to point out is that these things are baked in, and I want people to be aware of what they're signing so that they can make better purchasing decisions on what they want to enter into and what they don't. It's a big amount of trust that these companies demand. When I sit here in Virtual Legality and say they're unlikely to use these for any of the very bad reasons, some companies will. And they will develop a reputation that says, I don't want to enter into a user license agreement with them for those reasons. But it's important to note these things because this is the kind of language that leads to the provision up above that says you acknowledge that we can brick your system. So that's the state of play here. I did also pull up the earlier document just to point out that this is an area where Nintendo is changing things a little bit. You'll see that they elevated things that they care about in this earlier version in respect of individual arbitration. That's, again, another lawyer thing that you do in a license agreement is to elevate the stuff that you really want to make sure is enforceable, because some courts will look at a license agreement like this and say if it's in the middle somewhere and it's important, then we're not going to necessarily hold the other party to it because they didn't have an ability to negotiate this contract and they didn't know what they were signing away. This is the, you can't put in, you've sold your firstborn child in the middle of the document. The court's not going to enforce that anyway, but it's certainly not going to enforce it if you don't highlight that that's actually in the document itself, because nobody really expects the normal consumer to go through every word of these things. And that's its own problem in the law, and we could certainly talk about that on another video. But that's the state of play with respect to the Nintendo Switch, and then came the response. So here's the IGN article. Nintendo revises user agreement, and if you break it, Nintendo reserves the right to brick your Switch. That's IGN's headline. I think that's mostly a good headline that is identifying what is being stated here, even though we don't 100% know that Nintendo is claiming the right to brick the Switch as much as it is to cut off your access to the Nintendo service portal. We have other headlines. Who really owns your Switch 2? It's a me, suggests Nintendo, which I thought was amusing, so I highlighted here. Nintendo can brick your Switch and skirt lawsuits in outrageous end-user license agreement update from Hot Hardwire. And I think that is, again, the important aspect of this. This is obviously a headline designed to be incendiary, but again, the concern, if you have one, with respect to end-user license agreements on the whole, and certainly this one, if this popped up on your feed or you're otherwise seeing news items about it, is that Nintendo doesn't have to go through a court to turn your system off. Nintendo doesn't have to. It just has to claim that it sees something at issue with you potentially violating the terms of the agreement or becoming a commercial liability to them in some way. And then they can turn your system access off. GameSpot had the most incendiary version of this, and I thought that this was really not a great way to put this headline out. According to Nintendo's end-user license agreement, you won't actually own your Switch 2, and this has been jumped on in various places on the internet, and I still see it in the last week or two. And full disclaimer, I'm a Switch 2 owner. I love the Switch 2. And so you can take my words on that with a grain of salt, I suppose. I obviously thought the license agreement was fine enough for me to purchase this particular console. But GameSpot goes out with news like this. This gets repeated in various places on the internet. And it's one of the reasons you're seeing this video today, because I want to talk to you all about what Nintendo has the rights to do and what they don't have the rights to do, even in the contract terms that they have. So first and foremost, I want to point out again that what you're buying when you buy a Switch 2, when you buy a PlayStation, when you buy an Xbox, when you buy an MRI scanner and any other piece of technology in the world, is that you are buying a piece of hardware and software operating together. And when we talk about software, the contracts that are at issue here, we're talking primarily about copyright. So you make code and that operates your system, your hardware, and that code is copyrighted. It's protected in the nature of what it is as a creative work, rather than patented, which is undoubtedly what is covering the hardware that Nintendo actually sells you in the box when you go to the Walmart or the Target or where have you. Copyright protects the software, and copyright infringement law is what's going to govern the way that the end user license agreement is read by a court system. Now, that's important because one of the things that pops in to cover copyright in the United States is the Digital Millennium Copyright Act, or the DMCA, which you see most often referenced on the internet with respect to takedown notices and things to YouTube and the like. But it has one important provision that's really key to understanding this issue as it pertains to Nintendo and anything else that you might buy into in the video game space. That is the notion that the circumvention of copyright protection systems is itself outlawed. Mostly when we talk about copyright infringement, we're talking about stealing a picture of Mario and putting it in your own work in some way that Nintendo wouldn't like, and that's you using their intellectual property in a way that's unlicensed, and that's infringement. This is something different. This says no person shall circumvent, and I told you to put a pin in that word that they put into their end user license agreement this time, a technological measure that effectively controls access to a work protected under this title. And this provides an entire other avenue for these companies to try to protect their software, to say, okay, if we're protecting it through some kind of hardware or other mechanism, then if you circumvent that, we have our own independent right of action to sue you for infringement. And that's important, not just because they could sue you for infringement, but because it establishes in statute that the United States cares about preventing the circumvention of technological measures to protect copyrighted works, which means that when they put something in here in their end user license agreement that says, if you circumvent, we can turn off your software, then they think that they're more likely to succeed in a court case that somebody fights, right? When Nintendo hits that switch, they turn off your Switch 2, somebody sues them. They say, we can prove that you were trying to circumvent us with whatever you were doing piracy-wise. And they believe the United States courts will look at this and say, yes, the Congress has said we're concerned about that, so we are going to side with Nintendo. It's also one of the reasons why the language in the end user license agreement in other jurisdictions that are not under the jurisdiction of the DMCA do not contain the same language that we're discussing today. It's not just because the rules are different and are interpreted differently in the courts. It's because they don't have this particular concept in other jurisdictions, and Nintendo doesn't know whether the courts would allow for the enforcement mechanism that they're claiming in the United States. But that's important to understand this entire concept, because when we get further in, we see that that particular provision allows for civil rights of action, i.e. you can sue for damages and whatnot, which Nintendo could use in the future if they felt so inclined. It also includes criminal penalties if you are seen as someone who is willfully and otherwise violating that particular section. You're talking about years in prison, hundreds of thousands of dollars in fines, and that can be something that evidences, again, that the United States cares enough about this concept that Nintendo feels that they can say, we can shut down this software, and a court is going to back them up at the end of the day. I can't promise that one way or the other. Neither can the lawyer in the room for Nintendo. But if they were to pursue this remedy, they see there's some piracy, they're going to shut down access to the online store, or maybe even brick the system in its entirety. They are doing it on the premise that the circumvention of a technological measure to prevent piracy, to prevent copyright infringement, is something that the U.S. cares enough about that a court in the U.S. is going to backstop their ability to do these kinds of things. Now, on the other side of the coin, there are cases relatively recently, this is from 2017, that talk about companies that try to hard lock their ecosystem of products and not being allowed to do so. This is a patent case that's pretty famous in the patent world called Impression versus Lexmarks that talks about toner cartridges. Respondent Lexmark International designs, manufactures, and sells toner cartridges to customers in the United States and abroad. Companies known as remanufacturers acquire empty Lexmarks toner cartridge, including return program cartridges from purchases in the United States, refill them with toner, and then resell them. Lexmark argues that because it expressly prohibited reuse and resale of these cartridges, Impression products infringed the Lexmark's patents when it refurbished and resold them. Impression products moved to dismiss on the grounds that Lexmark's sales, both in the United States and abroad, exhausted its patent rights in the cartridges, so Impression products was free to refurbish and resell them. Spoiler alert, the court's going to side with Impression and say that Lexmark exhausted its patent when it sold the good into the line of commerce, and that Impression can take their toner cartridges in a different market, refill them, and sell them against Lexmark. This is a little bit like an antitrust case that we might have discussed in Virtual Legality before, but it's important to note that there are kind of threads of court cases in the United States that are looking a little bit more askance at the way these companies operate and take broad rights to prevent potential competition in these spaces in contexts like patent law. We're not talking about patents again, we're talking about copyrights in this particular instance, but it is worth noting that if Nintendo were to shut down some switches, then part of what the argument would be against their ability to do so would be that Nintendo is trying to cut off competition in some important way. And certainly Nintendo has a history of doing that. If you look at the Galoob cases and Game Genie in the past that really gave rise to modern emulation software law in the United States, Nintendo may be pushing too hard on this particular question if they were to shut down switches in regards to potential infringements, even with the DMCA sitting out there. So I do want to point out that this is a complicated point of law, even right now in the United States with the DMCA sitting out there, and Nintendo knows that. This is a lawyer saying we want to have this provision, but that is entirely different from Nintendo itself saying we're going to execute on that provision. So I think there are a lot of reasons to believe that Nintendo won't execute on that provision, that you do own your Switch 2 for all practical purposes, and that there isn't a lot to worry about here. But one of the bigger items that would lead me to that notion is that everybody else has a provision like this, folks. I know GameSpot says you don't really own your Switch 2, but that's only true to the extent that you don't own any piece of technology that uses a software operating system as of 2025. So let's take a look at the PlayStation Network Terms of Service and User Agreement to have that discussion. First, we note that this agreement that I've pulled up right now is with respect to access to the PlayStation Network. Again, Nintendo kind of collapses all of its software concepts into that one agreement for the most part. Sony doesn't do that. Sony actually has terms of service for the PlayStation Network where you buy games through their digital platform interface. And they also have a system software license agreement where when you talk about bricking systems and things that are going to really scare you, they probably more rightly belong. But since the Switch doesn't appear to have that dividing line, you get everything baked into the same agreement, and you get headlines like they say they can brick your system when maybe they're claiming that, maybe they're not. Because when we look at how PlayStation describes these things, and this is different lawyers for different companies, you see they describe the PlayStation Network, and then if we go a little bit further on, we get the same language that says it's a licensed concept. It's not sold to you. Every piece of software is licensed. And then importantly, it says in section 1.6, top line item, first section, breach of these terms may result in the temporary or permanent suspension of your console or your account. They specifically reference your console there in the Sony terms of service. Now, they also talk about suspension rather than bricking anything or permanently disabling, but permanent suspension and permanently disabling are not concepts that are different enough under my eye to say that they're a different concept for this purpose. Now, if we scroll a little bit further in this particular license agreement, we'll see that suspension does sound a little bit different when we get there. But as a top line item, Sony reserves the right to do very bad things to your PlayStation 5 if they determine that you've breached some aspect of this very long license agreement, including aspects related to community, right? User-generated content and how you interact with the Sony community overall, which we've covered in Virtual Legality as a potential problem because you shouldn't lose access to everything that you've spent money on because somebody doesn't like a bit of language that you've used in chat at some point on your PlayStation. But That's what this license agreement says. It says we can suspend you for all these very bad things. You bear all risk of loss for the things that you buy from us. You may not do any of these bad things that we talked about with respect to the switch terms. You may not reproduce or transfer content, use the content for resale, public performance, display, except as stated in this agreement. You may not create any derivative works. And that becomes important for these conversations because when you are on Twitch, when you are otherwise broadcasting on YouTube or wherever else you're playing your video games and having people watch you, that is in all likelihood creating a derivative work under the law that the various licenses that you've entered into when you purchased your license to your video game probably didn't allow for expressly. Now, there are some exceptions to that I've talked about in Virtual Legality before, like Minecraft has a very broad piece of language that says you can absolutely stream this under some specific rules. But for the most part, the baseline rule when you buy a video game is that you don't have the right to put it out there into the world. You don't have a right to do these various other things. That's one of the reasons why you see things get struck on Twitch, when you see things become an issue on YouTube. The limited license granted herein and all use or access to the content is expressly conditioned on your compliance with these agreements' terms. Except for the rights expressly granted herein, Sony, its affiliates, and everybody else that it has an interest in reserves all of its rights. Upon termination of this agreement, your account or license to any content will immediately cease. Continuing on a little bit further, again, very long document here. Console suspension, with or without notice. We may restrict, suspend, or terminate your PSN account and PlayStation device, your console, or indefinitely restrict, suspend, or discontinue your access to or use of certain PSN content, offerings, features, products, and services if you violate this agreement. Again, we can basically make that claim. Yes, you can sue us about the reasonability of that claim, but that's really going to be a problem for you more than us. With or without notice, we can turn your stuff off if we have a reasonable belief such a violation has or will occur. Again, there's that future-looking thing. We think that you might violate this agreement in the future. We have that reasonable belief. You have to prove it wasn't reasonable in order to win your rights back. It's a whole problem for you if you have a PlayStation 5, but it looks the very same as what we are seeing in the Switch documentation. This has been the Sony documentation for a very long time now. Upon termination of your account, you will not receive a refund for items, value accumulated, or any unused balance in your wallet, except for some specific rules in specific jurisdictions. And upon suspension of your PlayStation device, you will not be able to use that console to access PSN, play any games or game modes requiring online access, or access any content purchased from the PlayStation Store. Now that, honestly, sounds a little bit less problematic than what we see in the broad language used in the Switch document, but again, that's because Sony separates out its PlayStation Network account license from its system software license. So if we go and we look at that document, which we will right now, we can see some of the more scary language that you might be concerned about if you're a Sony PlayStation player. This agreement applies to any system software, firmware, and internet browser software and other application included in your PS5 system. All rights to use system software are granted by license only, and you are not granted any ownership rights or interest in system software. Now, that's normal, right? You don't think that by buying a PlayStation 5, you suddenly have the right to the system software that's operating that PlayStation 5, insofar as you could pull it from the PlayStation 5 and then sell it to someone else. You don't have that right. Nobody's really confused about having that right when you buy a console, but they have to put it in a license like this one so that it's clear for the law if it ever came up in court. Continuing on, if SIE, Sony, determines that you have violated this agreement's terms, Sony may itself or may procure the taking of any action to protect its interests, such as disabling access to or use of some or all system software. Now, it doesn't say it in as bright a line in black letter here, but if they disable access to your system software for your system is not going to work. That is bricking a system. This is the same concept as what everybody is worried about with the Switch, as what GameSpot put up and said, you don't own your Switch. I'm saying this so that we understand the ecosystem, not that you have to be happy about what's in the Nintendo license agreement or what's in the Sony license agreement. Just to note that this is happening across technological devices. It's not limited to game consoles in any respect. I used as an example earlier, medical devices. This is a big issue with respect to whether or not the provider of medical devices can turn those things off if they feel that somebody is violating the terms of service that they've entered into to operate that particular device. And that's obviously more important than whether or not you can play the latest Call of Duty, whether or not the MRI scanner can actually be used on your patients in the hospital. But that's where these legal questions get answered, is with really serious, really important stuff. And they haven't been answered yet. So Sony reserves the same right that Nintendo now claims. Nintendo was already reserving that right in their earlier terms of service, and yet we do not see a universe in which PlayStations and Switches are just being bricked willy-nilly because the companies decide that they don't like you. Why? Because that's bad business. They want to sell you Switches. They want to sell you PlayStations. And because they want to do those things, they are unlikely to engage in just crazy bricking of systems, and you can consider yourself the owner of the hardware that you have purchased, even though there is this right that these companies have established for themselves in their contracts and are likely to be upheld because they have to be able to control their software, and copyright prevents people from infringing on that software in general. Now, Microsoft is a little bit more confusing here because Microsoft, again, is primarily a software company and they draft their licenses primarily about their software overall. So they use a kind of broad umbrella agreement to talk about all the software they might sell you. That includes everything from Windows to Xbox operating software. And you have to kind of dig through various documents to get to what might be of most interest to you. We can see an Xbox section here that says the Xbox Online Service, Xbox Game Studio games, applications, subscriptions, and content provided by Microsoft are only for your personal and non-commercial use. They're licensed in general. They're not sold to you, etc. And then the bit of language that's the closest to what we're looking for here: for any device that can connect to Xbox services, like an Xbox, we may automatically check your device for unauthorized hardware or software that enables cheating or tampering in violation of the code of conduct or these terms, and download Xbox app software updates or configuration changes, including those that prevent you from accessing the Xbox services or from using unauthorized hardware or software that enables cheating or tampering. Now, that probably strikes most of you as a little bit less controversial than what we were reading in the Switch license agreement, because this is only talking about cheating or tampering. But from a legal perspective, when you talk about Microsoft deciding what tampering even means, that could easily be including the concept of pirating software and the various other things that Nintendo now expressly calls out. And you have to ask yourself whether you prefer a bit of language here that probably covers the same things that you're concerned about but isn't as clear, or whether you prefer Nintendo being very brightly worded in what it's saying it can do, and at least having the fight now before the fight would really be a problem in the future. My argument would be that I prefer that kind of bright line in the stand, say what you mean in these kinds of provisions. Microsoft having this bit of language here suggests to me as a lawyer the very same rights being claimed as what Nintendo's claiming and what Sony's claiming, but reasonable minds can differ even on that score. The point is that this is basically the same kind of license concept that you see across all systems, all pieces of technology that you would buy in 2025. You don't have to like that. You can think that there are laws that should be put into place that maybe prevent this or require you to go to court to enforce these various things. I would be open to that conversation. Certainly, when we talk about bricking systems, when we talk about cutting off system software, that sounds a lot like what we would talk about in legal parlance as self-help, right? If you've sold something to somebody and they didn't pay what they were supposed to pay, if there's some other reason that you have to go onto their property and take back what is yours, then for the most part, the law looks poorly at just going in, breaking and entering, and getting something, even if it is rightly yours under the law. We call that self-help. Instead, we require you to go to the sheriff and actually get the state or the jurisdiction that we're talking about to go and do that for you, so that we have some mechanism to prevent people from just being vigilantes and doing whatever they feel is right, because that's a kind of anarchic, not terribly useful way to function as a society. And you can definitely argue that the way that these licenses operate in real time is to allow these companies to have all this self-help, and we maybe need to have some protection against that. But it's important to know that Nintendo isn't doing anything terribly odd here. It is, in fact, just drafting their document in a more direct way by a lawyer that seemingly is more concerned about getting all of the specifics on the page rather than leaving things to your own kind of imagination, as Microsoft and maybe even Sony to a little bit do. But that's what I wanted to say about this topic. I think it's important. I really do think it's good that people are taking more interest in what is in the licenses that they're entering into. That's one of the reasons that virtual legality exists. And as I pointed out earlier, there are headlines and articles about the fact that the end user license agreement language differs in the United States and other jurisdictions. Part of that is because of the existence of the DMCA and the circumvention of technological security measures provision that we talked about earlier. Some of it is not. We can't really take anything as certain until we know exactly what Nintendo wants to do with that provision, and we are unlikely to know that in all reality because they're unlikely to do anything with that provision, in my view. That said, if you enjoyed this content, if you like hearing about things like the law and business of video games and other pop culture items that you might be interested in, please consider supporting Virtual Legality and this channel on the whole through Patreon, through memberships to the channel. We do live streams a lot, and through super chats on those live streams. I appreciate every little bit of support. I can't do it without you, and I think we're doing good work here to get this information out to more people. Otherwise, if you don't want to do any of those support mechanisms, that's totally fine. I get it. It's hard out there. Just subscribing to the channel for free, telling your friends that we're having these conversations, every little bit helps. And please do check out GameFile. I think Steven Tutello is doing good work over there, and I very much appreciate him identifying these things, even if I think some of the websites, like GameSpot in particular, went a little bit too far with what he identified. That's been Virtual Legality for today. Thank you so much for joining me, and I will see you on the next one.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.